What does a personal representative need to do before selling inherited property? A personal representative needs court-issued authority first, then a clean process to secure the property, review title, handle debts, follow required notices or court procedures, and close the sale into the estate account. Skipping those steps can stall closing or create fiduciary duty problems. I'm Rhett Fruitman, co-founder of Inherited Property Match. My background includes Citi Private Bank, CBRE, and helping families navigate inherited property sales across the country. This is general information, not tax, legal, financial, or real estate advice. Before you sell inherited property, speak with a CPA and, when probate or trust administration is involved, an estate or probate attorney. A personal representative is the court-authorized person responsible for administering the estate. If there is a will, that person is often called the executor. If there is no will, or the named executor cannot serve, the court may appoint an administrator. When real property is involved, you are a fiduciary, not just the person handling the house. How does a personal representative get authority to sell inherited property? A personal representative needs court-issued authority, usually letters testamentary or letters of administration, before signing for the estate or selling estate real property. Letters testamentary are typically issued when a will names an executor and the court accepts that person. Letters of administration are typically issued when the court appoints an administrator. Some states use different labels, such as letters of administration with the will annexed, so the exact document name depends on the probate court. Do not bind the estate, sign closing documents, or transfer property until the court has issued the proper authority. Title companies, lenders, brokers, and buyers usually want certified letters before they rely on the representative's signature. Can a personal representative sell a house before probate is complete? Usually, the representative needs court authority first, and the sale may also need court approval depending on the state, the will, and the type of authority granted. Ask early whether your authority is independent, supervised, limited, or subject to court confirmation. What should a personal representative do right after being appointed? A personal representative should open an estate bank account, secure the property, and confirm title before the property goes to market. Once appointed, obtain an EIN for the estate if needed. Estate income, repairs, taxes, insurance, utilities, and sale proceeds should run through the estate account, not through a personal account. Never mix the two. Then review the deed, vesting, and title report. The estate may not control the whole property if there is a joint owner, transfer on death deed, trust, life estate, right of survivorship, or another title issue. Before you talk price, ask whether the estate actually controls the property. What happens to sale proceeds from an inherited house? Sale proceeds should go into the estate account, then be used to pay valid estate expenses, debts, taxes, and administration costs before any distribution to heirs or beneficiaries. How should a personal representative protect inherited property? A personal representative must protect inherited real estate by keeping it insured, secured, maintained, and protected from avoidable loss. If the home is vacant, change the locks if appropriate, manage utilities, confirm insurance coverage, pay property taxes, and prevent deterioration. Vacant homes may need different coverage than occupied homes, so review the policy immediately. You should also get a reliable date of death valuation, often through a formal appraisal. That valuation supports pricing, helps show the estate pursued a fair sale, and helps with tax basis analysis. Save photos, repair invoices, insurance records, and a written timeline. If a beneficiary later asks why a decision was made, the file should answer the question. What debts, notices, and heir issues must be handled before closing? A personal representative must identify valid debts, follow required notice procedures, and avoid distributing sale proceeds before estate obligations are addressed. Before closing, check for mortgages, recorded liens, unpaid property taxes, HOA balances, judgments, and other encumbrances. A title search helps, but it does not catch every estate debt or creditor claim. That is why the estate attorney matters here. State law and probate authority may require notice to heirs or beneficiaries, time for objections, or court approval before closing. Limited or supervised cases may need court confirmation. Some states also allow overbidding at a confirmation hearing. Can a personal representative sell inherited property without all heirs agreeing? A personal representative may be able to sell without unanimous heir approval if the will, the court, or state law gives that authority, but notice rights, objections, co-owner rights, and court procedures can still affect the sale. How does a personal representative choose a broker and close an estate sale? A personal representative should hire a probate-aware real estate broker only after confirming sale authority, title issues, and any required court or heir notice procedure. Your probate attorney should review the listing agreement before you sign. A defensible broker process usually means interviewing more than one broker, comparing probate or inherited property sale experience, and checking pricing against the date of death valuation and current market evidence. Can an executor sell a house below market value? Selling below market value can create fiduciary duty problems unless there is a documented reason, proper market exposure, legal advice, and any required court approval or beneficiary consent. At closing, the court-authorized personal representative usually signs for the estate, using the authority shown in the letters testamentary or letters of administration. The net proceeds should go into the estate bank account, not a personal account. What fiduciary duties does a personal representative have? A personal representative has duties of care, loyalty, accounting, and following the will and court orders. In plain English, that means maintain the property, avoid self-dealing, keep records, communicate where required, and make defensible estate decisions. Buying estate property yourself is a major conflict issue. Do not do it without full disclosure, legal advice, and any required court approval or beneficiary consent. If valid debts are paid too late, if sale proceeds are distributed too early, or if property is sold below fair market value without support, personal liability can follow. The safest pattern is simple. Act like a fiduciary, document everything, and do not rush the sale. What is the checklist before a personal representative sells inherited property? Before a personal representative sells inherited property, the checklist is authority, title, estate account, insurance, valuation, creditor claims, heir or beneficiary notice, court procedure, broker selection, closing paperwork, and records for the final accounting. If you inherited property and need help finding a broker who understands estate-related sales, Inherited Property Match can connect you with a broker screened for inherited property and probate-related sale experience. The match is free. You can also find more guidance on probate, title issues, and inherited property sales at inheritedpropertymatch.com.